Alors, on poursuit maintenant avec notre premier panel de la journée. Je vous avais dit qu'on allait avoir et des conférences et des panels. Les panels, c'est intéressant dans le sens que vous allez pouvoir également poser des questions à la fin, mais on va forcer justement nos experts à aller un petit peu plus loin dans le sujet. Alors, j'invite tout de suite à me rejoindre sur scène Monsieur Martin Couillard qui va animer ce panel ainsi que ses invités. Et j'ai nommé Dr. Ken Porter, Dr. Mark Weber et Dr. Valérie Bonnardel-Vacqué. Et pour faire une petite présentation de Dr. Couillard, Dr. Couillard était notre ancien président sur la 11e édition du FORPIQ et il est aussi membre du conseil d'administration du FORPIQ. Mesdames et messieurs, votre premier panel qui va parler du mythe versus réalité sur le transfert de la technologie.
Merci Béatrice, thank you. So yeah, I was the president of the last edition, which was online only. So now it's very fun. It's a real pleasure to see you live en personne. Donc I will do the presentation in Franglish as we do in Montreal. I'm involved at the FORPIQ, but I'm also je suis directeur principal donc les relations avec les partenaires de la recherche publique chez Axelys. Donc rapidement, Axelys présente le panel d'aujourd'hui. Axelys a été créé en 2021 par le ministère de l'Économie et de l'Innovation, maintenant le MEIE. Donc la mission est de contribuer à la prospérité économique et sociale du Québec en accélérant le développement et le transfert d'innovation à haut potentiel issu de la recherche publique. Voilà. Et puis, donc Axelys est heureux de présenter ce panel. Puis, donc, le but, c'est de démystifier un peu les perceptions des entreprises qui ont envers des fois l'accès à la propriété intellectuelle issue de la recherche publique, aussi de l'impact du transfert technologique dans la société. Donc, j'invite nos trois panélistes à venir nous rejoindre. Pendant que vous vous installez, je vais vous présenter. Donc, on a Ken Porter, aussi Dr. Mark Weber et Dr. Valérie Bonnardel-Vacqué. Donc, pour ce qui est de Dr. Ken Porter, directement de la visite des États-Unis, ici, donc, de l'Université du Maryland. Dr. Porter is the director of the Tech Transfer Office at the University of Maryland. It's called the Venture College Park. Now he has many experience in welcome. In tech transfer. He also managed the tech transfer office in Colorado, in Texas, and also in Alberta when he was involved in the Innovate Calgary, where he was the director IP and social clinical innovations. So Dr. Porter has a PhD in chemistry and also an MBA from the Duke University. And he's also a member of many organizations like the Licensing Executive Society and the HOTM, which is an association for the tech transfer manager. Which is the same thing for Mark Weber. He's involved also with the HOTM Canada as a guitar player. Can I say that?
I dabble.
Each meeting he plays with a band donc, Marc, tu vas nous jouer la guitare après le panel? Tu as amené ta guitare?
Non, pas aujourd'hui.
Ah, merde. OK, la prochaine fois. OK. Let me introduce you in French, it will be fun. So, donc, Marc a eu sa carrière à l'interface de la recherche de la R&D et de l'entreprise et de l'innovation universitaire. So he worked at McGill since 2012 as a director of the Innovation and Partnership. C'est d'ailleurs un ancien élève de McGill. Il a complété ses études de premier et deuxième cycle et de maîtrise doctorat en génie chimique. Et aussi travaillé chez Nova Chemicals pendant plus de 10 ans et dans des cabinets conseils d'ingénierie, dans 2 startups. He's inventor of many patents et a négocié plein de licences avec des entreprises de tailles différentes. Et puis, donc, il est reconnu pour ses contributions dans le transfert technologique universitaire au Canada. Et je voudrais aussi rapidement introduire ma collègue Valérie Bonnardel-Vacqué qui consacre sa carrière à établir des liens entre le milieu universitaire et l'industrie. Et puis, elle est titulaire d'un doctorat en chimie de l'Université de Lille et une maîtrise en ingénierie de l'École centrale de Marseille. Elle est actuellement ma collègue directrice principale de développement des affaires chez Axelys et auparavant, elle a entre autres travaillé dans des entreprises telles que AkzoNobel et L'Oréal. Elle s'est investie pendant près de 10 ans dans l'essor de la recherche universitaire collaborative, donc en France, à titre de directrice générale de la Fondation partenariale de l'Institut national polytechnique de Grenoble. Et au Canada, chez MITAX, elle a aussi été directrice du bureau de soutien de l'innovation de la faculté des études supérieures de la recherche de l'Université de Moncton. Et voilà, donc, without further ado, we'll start with a short presentation by Ken about the ecosystem of innovation, what is the impact of technology transfer in it, and also the difference and mostly the similarities between US and Canada in terms of technology transfer activities. The floor is yours, Ken. Thank you.
Thank you, Martin. Can I use this microphone? Yes. Great. And you'll advance the slides for me? Thank you, Martin. Thank you for the nice introduction. Thank you for inviting me to this panel. Thank you, David, for inviting me. It's an honor to share the stage with Valerie and Mark and to speak to you about intellectual property and technology transfer. So intellectual property in particular developed at universities. And the similarities between the U.S. and Canada and their approach to managing intellectual property. And the take-home message is that it's very similar, but with a few nuances. So first, about me, I'm at the University of Maryland. We are in College Park, Maryland, which is a suburb of Washington, D.C. We're about 8 miles from the White House. We have 40,000 students, $600 million in research expenditures. About 175 disclosures come to our office a year, and from that we file about 250 patents and have about 60 patents a year issued. And I've been at Maryland for about 4 years. I was at Calgary from 2013 to 2018, so got some experience in the Canadian perspective. Moved back to the United States to work at the University of Maryland in 2018. And of course, we spent the first year doing a strategic planning exercise with our various stakeholders, and this is what we came up with. So our mission is to transfer discoveries into products and services that deliver economic and societal benefit. That's our mission. And our objectives are to support faculty and student innovation, entrepreneurship, and industry engagement, start companies, secure investment, create jobs, provide experiential learning opportunities for students, so law students, business students, and scientists who are interested in entrepreneurship, create revenue, and drive University of Maryland impact. And I put this up here because I think that any university would want to do something similar. So in that regard, US, Canada, Europe, Japan, all technology transfer have similar aims. And that was kind of driven home in 2017.
Take care of your mic because it's a strange range. Your mic.
How about if I just hold it? Hold it? There we go. So 2017, the Standing Committee, House Standing Committee on Industry, Science, and Technology took on about a year-long study of Canadian university intellectual property and technology transfer. And their conclusion was the aim was to have a significant positive impact on the Canadian economy. So very similar to what I just told you, that's our aim at University of Maryland, Mark's aim at McGill, and all other universities, is to have a positive impact on the economy and the world economy and the world society. And in that, in the testimony towards this report, there were 19 briefs and 27 witnesses. And I edited one of the briefs for our professional association, Autumn, submitted it to the committee, and I was also one of the witnesses. And along with me as a witness was Steve Zasalka. He was the CEO of Autumn, and he did a comparison of US and Canadian technology transfer metrics. And here's what he found. So if you look at 2015, the column on the left, looking at research funding, Canada, the ratio of Canada to U.S. Research funding is about 10 to 1. So similar to the population, similar to the gross domestic product, similar to the similar comparison among many dimensions, the U.S. and to the Canada to the U.S. And what he found is when you normalize for this difference in size and you look at the common technology transfer metrics, you find that, so for disclosures, Canada discloses about 80% the rate of the U.S. about 70% of the patent applications, and these are US patent applications. We don't have a number for Canadian applications. But for options and licenses, just about the same as the US, 96%. And so actually Canadian universities are doing more with less. So they're filing fewer patents, getting fewer disclosures, but executing just as many licenses. So a bit more efficient. That way, so about the same with startups. License income less, though, about 25% in 2015. I looked at the 2021 numbers and came up with similar numbers for disclosures, patent applications, options and licenses. Startups, now Canada is outperforming the US 140%. And how that translates into numbers is that the US is starting about 1,000 companies a year, both in 2015 and 2021. Canada increased their rate from about 100 companies to 125 new companies in 2021. License income also, there's been some improvement there, about 39%, still relative to 25% in 2015. So we have similar aims, we have similar outcomes, but not identical. And there are many factors that can play into why, where those differences come from. And I can't give you an exhaustive list of that. But one pronounced difference between the US and Canada is their approach to IP ownership. So in Canada, it's determined solely by university policy. And it can be, the IP that's developed through the research enterprise can be solely owned by the university, like at UBC, McMaster in Ottawa. It can be owned by the creator, by the faculty member, and that goes along with European tradition. Alberta, Calgary, Queens are all creator-owned IP. And then it can be jointly owned, like at Toronto and McGill. In the US, it's uniformly institution-owned. And it's uniformly institution-owned because the government, which funds a large percentage of the research that goes on at the university, enacted law in 1980 that mandated or that offered the university ownership of the IP. And they did so for a reason, and I'll take you through that. So first, where did technology transfer come from? Where did government-sponsored research come from? And so if you look at the US, the first technology transfer happened in 1879 at Johns Hopkins University. So Johns Hopkins University is also in Maryland. It's about 30 miles from my home. 1879, researchers discovered saccharin from toluene research. And of course, we still use saccharin today. And so that's noteworthy in that it's the first tech transfer, the first time products have been developed from university research. And also noteworthy that Johns Hopkins University was the first research institution in the United States. Before that, U.S. universities taught the classics, but Johns Hopkins, in their mission, put research in the mission. And Johns Hopkins was founded in 1876, and so just 3 years later, in 1879, was the first tech transfer. So tech transfer and IP has been a part of university research since the beginning. The first academic license was actually the University of Toronto when they licensed insulin to Lilly. So what are the foundations of this? What are the foundations of technology transfer? In the U.S., first, Western tradition. So patents are a really important part of technology transfer. The first patent was 500 BC in Sybaris, Greece. Chefs were offered a one-year exclusivity on new recipes. It's in the U.S. Constitution, so that's 1788, Article 1, Section 8. The Patent Act in 1790. Thomas Jefferson was the first head of patents in the U.S., and he personally reviewed all of the applications for the first 3 years. George Washington signed the first patent. And so the other part of tech transfer is government-sponsored research. And so government-sponsored research happened after World War II in the U.S., started in 1945. And then a major change in technology transfer happened in 1980 with the Bayh-Dole Act. And of course, university policy ties all of these things together, just like it does in Canada. Government-sponsored research started in 1945. A professor at MIT, Vannevar Bush, who was also founded Raytheon, published a paper called Science, the Endless Frontier. And in it, he postulated that if the U.S. was going to build a technology-oriented economy, that government labs wouldn't be sufficient to support it. And so he postulated that the government should fund basic research that will support this technology economy, and that the U.S. universities should be the engine that delivers the innovations. And that took hold, and from that paper and that postulation came 3 funding agencies: the Office of Naval Research for Defense Research, NSF, the National Science Foundation for Basic Research, and the National Institutes of Health for Health Research. And IP was part of this funding from the beginning. So eventually there were 26 granting agencies with 26 individual IP policies, so a real mess. But in general, for government-sponsored research, the government owned the patent. So assignment went to the government, and the government's mandate was that all U.S. companies would have access to the IP. So it was all licensed non-exclusively. And so with non-exclusive licenses, in many cases, if there's no exclusivity, there's no investment. And so what happened was that many patents were filed, few were licensed, and fewer products were developed. And I'll just make note that this notion that patents should be freely available was also part of the testimony in that 2017 report. And so the U.S. has tried that and found that approach wanting. So in 1980, Congress passed a bill, the Bayh-Dole Act. And it was a recognition by Congress that imagination and creativity are a national resource, that the present federal policy was placing the nation in peril. So this notion of equal access to all IP, government IP, was placing the economy in peril. The patent system is the delivery vehicle, so Bayh-Dole doesn't apply to copyright, but university policy brings copyright and patent into congruence. And as well, all university research isn't federally funded, but because a preponderance is, university policy harmonizes and makes uniform the approach to be consistent with the Bayh-Dole Act. And the stewardship is best managed by the contractors, that's the universities. And so what is it? It applies to all federally sponsored research. Researchers the universities accept the grants on behalf of the researchers. The researchers conduct the research, agree to disclose IP to the universities. Universities agree to disclose the inventions to the funding agencies and tell them when they're going to elect title. They have 2 years to file a patent. In the patent, they have to indicate government support, and there has to be a license, a non-exclusive license, back to the U.S. government to practice the invention. So in exchange for those relatively light obligations, the university has the opportunity to take assignment of the IP, and more importantly, or just as importantly, exclusive licensing is enabled, and that's really the economic driver. And so what happened? So if you look prior to 1980, prior to Bayh-Dole, 250 patents per year. Look in fiscal 2021 alone, 8,000 patents issued. Economic impact, again, 1 year, fiscal 21, 10,000 licenses, 1,000 startups, 6,000 startups operating, and nearly 800 new products introduced. And BIO, Autumn, our association, along with BIO, the Biotech Association, did an economic impact study in 2021 and found that from 1996 to 2020, university inventions supported up to 6.5 million jobs, $1 trillion to the U.S. GDP, and nearly $2 trillion to industrial gross output. And here's an example of some of the successes of U.S. academic tech transfer: Honeycrisp apples, flu misc, pacemaker. My dad just got a new pacemaker last Friday. He wouldn't be alive without it. And so that's kind of an introduction to U.S. and Canadian approaches to technology transfer.
Great. So thank you, Ken. So that set the stage for the panel. Where we decide we will tackle 5 myths around tech transfer activities, and what I will do. Do you have the slides for the myths, or if not, I will just mention them. Yeah. Go to the first one. All right, about IP on ownership, we mentioned a little bit about it. So let me use another voice because I don't want to be personally associated with this statement. So as an entrepreneur, I need IP assignment from university to attract VC money. So you can talk a little bit about the Bail Act, which is this kind of statement is less involved in U.S. But Mark, can you mention? Have you ever heard this statement before? Or?
More than once.
Yeah.
And I understand. So my background is as bringing industrial R&D to commercialization. So I think in Canada is a little bit different than the U.S. So attracting VCs is harder. There is definitely a number of VCs who like to see IP assignment to the company and take the university name off the patent. So it's not necessary, but it can be helpful. So I think you just have to sort of do it case by case. So I can tell you at McGill, we will assign IP when it makes sense and where it makes sense. We don't do it right away, and the reason we don't do that is if you do assign something and then the company goes belly up, who gets it back? And that's actually quite complicated. So what we typically do is if assignment does seem to make sense, it has to happen after a number of milestones, including investment, including meeting performance milestones, which shows the company's actively trying to get this to market. It has investment. It has to have paid back all its outstanding patent costs. It's actively trying to develop something, then we'll consider it. But it's not a necessity. Certainly there's some schools that won't do this at all. Some that do it because they're inventor-owned, so that happens. So this is what happens in Canada. They could say, well, I can go to Waterloo and get an assignment right away. Why can't I somewhere else? So I think it has to be a little bit case by case, so I don't always buy the request to do this, but if the company's serious and is willing to work with us on a set of milestones and conditions where it makes sense, then we will certainly look into it.
Well, I fully agree with what Mark said. It's absolutely a case-by-case basis. The way we consider it at Axelys is exactly the same way. It's meaning that we have at heart that all the IP generated by publicly funded research have an impact on the community and on the society. So that's what we drive all over through the transfer and commercialization process. So it's very important to keep in mind that all the inventions are not ready to be a product on the market. So they need a lot of work. They need, of course, IP protection, the proper IP protection, and they also need some maturation, technological maturation, and improvements and capitalizing on the know-how as well that exists within the inventors in the labs. And during all this time, of course, there will be someone that is interested in the IP, and that's why we promote the license before the assignment to the company, because we want to continue helping all this melting pot and all this magic happening for the invention to become a real innovation on the market. So, but of course, at one point in time, if the assignment is an opportunity, and we've heard a lot of very interesting talks before on how this can generate revenues and assets for a company, so we are going to consider that. But if I have a message to pass through to the VCs, maybe there are VCs in the room here, is don't fight to get the assignment right away, because I think by doing that, you are missing the point in having a real innovation on the market at the end of the day, where you can really assess the value and where you can really have the opportunity to invest properly and have something that is going to bring you back money. So, so please don't fight for the assignment, but help us getting these startups or the companies the right money to make this invention go to the market.
Yeah, and I think just to, the final thing is, at the end of the day, we want to have great products get out there helping people. There's lots of ways to do that, but the key is that they're actually being, the monetizing is part of it, but brought forward, they're commercialized, there's an effort. And we've done a couple of licenses to major companies. If I said their names, you would know totally who they are. And you'd think, that's perfect. These are massive companies. Something good's going to happen. Well, often that just goes into a pile in a big portfolio, and they'll get to it when they get to it, and two of them are actively not doing anything with it. That's the worst. So we don't want that. We want the stuff to be actively used and making a difference. So the ways to get there are numerous. We try to do it case by case so it fits. So at the end of the day, everyone benefits from these innovations.
Could I just add that in the U.S., under bi-dual assignment's not allowed, and certainly there's VC investment in university companies in the U.S., so it's not necessary, but it's a nice tool used, as Valerie and Mark have used judiciously, as Valerie and Mark have said, so that definitely is an advantage to the Canadian system.
So it's bringing me to the myth number 2 about the negotiation process. So it will take 2 years to get a license from, too long, yeah? Let's say, to get the license from a university, and they are going to blame me to death. Valérie, would you like to start this one?
Well, not only this is something that we hear very often, and I must say, if experts of tech transfer and commercialization didn't exist, like the ones that we are here, this might be the case, and this will not be a myth anymore. This will be a reality. But because we are here, and we are the people to help the transfer and to make sure that there is a benefit for everyone. So that's why when we negotiate a transfer, when we negotiate a license, we keep in mind that what is important is pace, so timing, the right timing, and also that the license will bring benefit and everybody wins at the end of the day. So, of course, if you ask an inventor, a researcher, anywhere, whether he's in the university or in his garage, he has his technology and he wants it to go to the market. If you ask him, of course, he will tell you, this is the, well, 8th wonder, of course, and it's worth millions, and I want millions for that. But there is an education to be done to inventors and researchers that this might be the truth, but after a long, long time and an awful lot of work still to be done on the technology and on the invention. So, and for it to become a reality, a product on the market, he will need money, he will need people to take the license, he will need his IP to be protected. So this has to lower his expectations in terms of what his invention can bring him. But if he goes to the right people, to the right expert, to the right environment to make his technology become mature and ready to be transferred, then the transfer will bring in the right value of the invention. So for a company that wants to acquire technology, are they going to bleed to death? Of course not. And if they come to us to get the right license, of course they will not. And at the end of the day, everybody is going to win. And also, the impact and the benefit for the community is going to be great if everybody keeps that in mind.
You want to go, Ken?
Sure. So kind of two parts to that question. One about the length of time of the negotiation. So we create boilerplates that for our licenses that adhere to the requirements. We're a state institution, and so we have state mandated provisions in the license such that we can't indemnify other parties. We can't be sued outside of court, in courts outside of the state of Maryland, and those are just how we have to operate. And we find actually that we have a bimodal distribution in the time to license. Some people sign right away because we really do have the minimal requirements in our license. Others take up to 6 months to redline our license and then to come back around to where we started, because what's in our template is what's required. And then the notion about bleeding to death. So economic consideration is part of the license, but we certainly we look at it as we want the low side of fair. So we can do financial analysis as well as anyone, and we're not trying to get top dollar. You saw my mission just a minute ago is not to generate maximal revenue from each property, it's to make maximal impact. And the way we do that is we get that in the hands of entrepreneurs and companies.
Yeah, and to build off what Ken said, the timing, it really comes down to the things that we can negotiate and what we can't. If you want to negotiate consideration, that's no problem. We're happy to do that. If you want to start negotiating indemnification, reps, and warranties, as you know, people say, there will be lawyers. And so now you've lengthened it dramatically. And you may have to come back exactly where you started. So all you did was waste, and we did, was waste a number of months really on something we can't move on. So I would suggest for anyone out there, from a company perspective, the things like that we can't touch aren't worth trying to tweak and see what you can get changed. Leave them, and if it's a consideration, we're happy to work on that because that's a case-by-case basis. And pharma looks so much different than clean tech, which looks so much different than AI. So we're happy to do that. We understand that, as Valérie said. And the second point on the consideration is that I know from years past, I think it was more challenging. We've heard that, 10, 20 years ago, it was like pulling teeth to get the university to move on a value. They thought they had invented, the eighth wonder of the world and deserved a king's ransom for it. I don't think that's the case anymore. And we are educating our researchers, which is a big part of it. This is a marathon and you've run 100 meters. The company really has to do the rest, and thus we need to be commensurate with that approach in what we ask for. And I think the education's getting better. I think there's slow improvement on that, but hopefully the goal is really just to get great ideas out there helping people. We want this to be a success. We want you to be a success. We just want to be fair in whatever the terms are.
So let's move to the myth number 3 about a quick question briefly about the chain of title. Listen, I will have to negotiate with all the inventors. Is it true? Mark, would you like to start?
Well, certainly at McGill, we have a joint IP policy, as Ken pointed out. If the inventors choose to take it on their own, which they can, you may have that case. But if they work through our office, no, you just negotiate with us. So if there are inventors that are sharing revenue, that's an internal matter. That has nothing to do with you as a company. So we do share revenue that we would receive with those inventors. Again, an internal matter. That's all handled, hopefully, by the initial disclosure to us. We know what the revenue share distribution is going to look like. If it has to be modified because a new inventor's added, or it changes because, of course, the patent may have some inventors drop off, we'll take care of that. So you don't have to do that. You negotiate with us. Even if it's an equity component in the deal, the equity's held by McGill, but we would then distribute to the inventors. So you don't have to go chase them down for signatures, for example. You would just come to me, I would sign it, and you're good to go. So at least with the way we work, that should really not happen. You don't have to negotiate with the inventors. And we try very hard to keep them out of the negotiation because they're very poor at this. Their understanding is low. They all think they have Google or Lyrica when they likely don't. So we try to keep them really out of the equation. You're really just dealing with professionals who are more attuned to what your needs are and to making a fair deal.
Yeah, well, at Axelys, we are the non-for-profit organization that has been set up by the government of Quebec to transfer and commercialize innovation from the public research. So, well, universities, hospitals, colleges, whatever. So some of the universities like McGill, they have their own transfer tech people, but some other universities have not. So they go through Axelys, and Axelys operates like what we call in French the voile corporatif, which means that anybody that is interested in a technology will not have to deal with the inventors in negotiating the license. We will do it. So we act as a kind of a neutral third party. And again, we try to make it work for everyone so that the benefit is there, everybody wins. And of course, there is one single focal point for the negotiation, and these are the experts at Axelys. So, of course, in all the process of transferring and valorizing, that's not a real English word, but la valorisation des technologies, of the technologies, we assess everything from the technology by itself, the intellectual property, the best way to protect this intellectual property when we consider it going towards a certain market. So we do the market assessment as well. And then we go to the outside world promoting these type of technologies to find the best possible vehicle for commercialization. So whether we have to create a new startup company, or we are going to transfer this IP to an existing company, whatever the size. And it's at this moment that the negotiation takes place for the license. And so you understand that all the work that has been done is helping the negotiation. And again, the important thing is that the technology is ready to go to the market. So that's why we're here, to gather all the expertise and make it happen. So again, to answer the question, as for McGill, no, you will not have to deal with all the inventors. You'll have to deal with one single focal point at Axelys.
So another provision of Vital that I didn't mention is that revenue is to be shared with the creators. And at the University of Maryland, any revenue that we collect from our IP is shared 50% with the creators. And under state of Maryland ethics law, for a university professor to negotiate that license or participate in the negotiation, that would be forbidden under Code of Ethics. And so actually negotiating with inventors in Maryland, at the University of Maryland, is prohibited by law.
Great. So let's talk about the famous disclosure. Myth number 4, I'm losing all competitive advantage if the inventors can publish. Valérie?
Well, academic researchers, they do want to publish. And in every licenses that we have, there is this right that is allowed for the researchers and inventors to publish their invention for academic purposes. And this is really the key word. Of course, a company that is acquiring through a license or an assignment, at the end of the day, a technology, what they have is an invention, and they really have something that is going to be on the market. It's protected through IP, so the whole set of protection, whether it's a patent or any other set of protections for IP. And it's the company that is going to build the competitive advantage for his or her product, and not the technology, not the science. At the university, the inventors want to publish the science, and so it's two different things. And the company is not going to lose any competitive advantage as soon as the company understands that it's in their hands. The competitive advantage is in their hands, and if the intellectual property is rightly protected, they are going to build it for several years. And they have to entertain this competitive advantage. They have to be good on the market. That's all the companies are here for. Researchers, they are here to do good research, to continue inventing and providing the community with state-of-the-art new things and what builds the future. They have also the mandate to train the talents in the universities, and these talents are going to move to the companies and also contribute to getting a competitive advantage at the end of the day. But there needs to be publication for the academia and the research to continue, and the researchers to, get their recognition by their peers. And what we want in Canada and also in the US is that our research and the intelligence of our researchers is recognized everywhere in the world. We want to attract talents. We want also all this intelligence to go to the market and be transferred for the companies to get the competitive advantage. So again, it's not something that it's not two things that exclude each other's. Sorry for my English, I'm losing my words. But it's complementary, and again, the tech transfer and commercialization are here to build the competitive advantage and let the university researchers continue to do the good research that we need them to do.
So just to say that they're not mutually exclusive, I totally agree. A lot of it's in the timing. So if you can hold off publication until you've got something into the patent office, that really helps you get broader coverage. So really that's it that we try to make sure is if we can manage the timing, that helps us a lot. It can potentially help the licensee down the road because you could have broader coverage. And I will say a lot of the stuff getting into papers is a good thing because it's marketing for you. And then instead of having to sign NDAs, I can say, oh, here's something. It's already in the public domain. Let's start with this. If you're interested, then we can have deeper conversations. So if used properly, actually the publications help everybody. And the previous speaker talked about security risks, which are a reality, unfortunately. And we don't do secret research. It has to be published. That's part of it, too. So that really fits with what you just saw and where our researchers need to take it. But if we can do the timing, there would be no negative benefit to the company. Ken, maybe you can talk a little bit about how you do some of your publications with your patenting strategy, which is a little bit different at Maryland with regards to getting it out in the public domain first and then seeing what happens.
Well, are you talking about the grace period in the U.S.?
Yeah, exactly.
So in most of the world, in order to get a patent, there has to be absolute novelty, so no publication before the patent filing. And in the U.S., that's modified a bit. In that in certain circumstances, you can have a one-year grace period, so inventors can publish, and we have up to a year to file a patent application in the U.S., so we just have U.S. rights for such applications. So that in that way, U.S. patent law aligns very well with university research. But this notion of the competitive advantage, also that's built into the patent, the notion of patents, and that there's a tension in the deal for a patent and between the inventor's rights and the benefits to society. And so the deal is that the inventor invents something and then teaches society how to do it, and in exchange for that gets a period of exclusivity. And in teaching society, it drives innovation further for others. And so having a publication in advance of an academic publication in advance of the patent publication, it does add a new wrinkle. But there are many wrinkles associated with IP and working with university researchers.
Oh, great. So one last myth, because it's related to the famous time to market. So working with researchers is a waste of time. They are too far from the real problem. I think, can you talk to me about the difference between curiosity-driven versus problem-driven research?
Exactly, Barton. That's how I look at university research. Curiosity-driven, which is what people think of with basic research, and actually what BIDO was enacted to address. But there's also problem-driven research, and we see that especially in our engineering schools, where faculty want to solve problems that real people face in real time. And actually, when we were in Canada, we had some success in going to industry and finding the issues that they were facing that might be addressed by academicians and research at universities. And of course, we were in Calgary, so it was the energy industry, and they kind of gave us broad examples of where they thought our researchers could contribute. And then on the other side, we had 40 academic institutions banded together so that we had resources available that weren't just at the University of Calgary, but were available from Manitoba to Vancouver. And then we hired 7 business development professionals to do the matchmaking, to talk to industry, ascertain their problems, talk to faculty, ascertain their capabilities, and do the matchmaking. And so yes, basic research can be a long, long way. We were talking yesterday about quantum research at the University of Maryland. That's a long, long way from realization in the market in most cases. But exercises in understanding each other can bring the two sides closer together.
Mark, Valérie, would you add something?
I'm just going to say that it's really hard to do blue sky research now. The funding is hard to get. So you really do need, as a researcher, to pair up with industry or to actually solve a problem. So, I mean, yes, it's true. We often invent solutions looking for problems. That's what happens when you're out on an edge in research. But often it may be just a couple of years, and now that really starts to take off. We've had several inventors who were just a little early to the market, but now they're really engaged because they came up with something super cool that now other people want. So I think Ken's point is right, that there is, yes, some truly basic research, but now it's becoming much more problem-driven for most, and especially newer researchers who really want to get actively engaged with companies, because that's the easiest way to graduate students, to get people working on real things, getting better talent coming into your lab. So I think it's changing, and certainly we're also trying to push that idea. Let's make sure, I've brought lots of products to market, and a market pull is a whole lot better than a technology push.
Well, I fully agree with that, and I can give you a different perspective. I used to work in a very, very big company that was filing about 700 patents per year by itself. And the strategy of this company was, we are collaborating with academic researchers through what we call collaborative research. When we have a problem, we have a question, and we know that there are lots of knowledge and intelligence in the academic lab that we can trigger with our problem and ask them to solve the problems, very specific problems. So we ask the question, we pay for it, so it's collaborative research. There are lots of grants coming in, to leverage the dollars that were put over there. And then, of course, the IP generated belongs to us as a company. And so that was one part of the strategy. But the second part of the strategy was, we know that there are lots of researchers that are really knowing what are our future challenges. And it's very interesting to get to know these people and to look at them not as a source of intelligence and of hands working in the lab, but as a source of technology that we can license and that we can mature in our own labs internally of the company to make it our own and to make our products with that. So these were the two parts of the strategy of this company, and that worked really great. So for us, and now if I can revert back to what we do at Axelys, we believe definitely that it's very important to get a knowledge of the market needs, so to really do market pool, so bring the market intelligence to the labs, because the researchers now are getting to be really willing to do research based on what the markets are giving them in terms of ideas. And then we are here to make sure that once they have a technology ready for transfer, we are able to connect them with the right preneur, we say, taker in English, to transfer the technology and to have the proper license at the end of the day. So I think it's a really new way of thinking, and I fully agree that the new generation of academic researchers are thinking like this, and they are really waiting for us to bring them the insight of the market in order to have the research done to solve future problems and have it transferred properly to the economy and ecosystem around them.
Merci Valérie, thank you. Thank you, Mark, Valérie, Ken. We might have some time for questions if you want before the coffee break. We have less than 5 minutes to one or two questions.
Maybe two.
I'll speed up. Very simple question. I'm Sylvain. I'm involved in IP transaction, valuation, work for CERN, EPFL in Switzerland, kind of thing. What's your policy experience about downstream IP whenever the researchers is involved or not with the assignee?
So do you mean if, so you have the base IP and then there's new IP built on it?
Absolutely.
Yeah, so that's always a good question in the licenses. I can tell you, in the old days, we would say, well, that's a new license. We don't really do that anymore. If it's built off the original IP and literally couldn't be practiced by anybody else, like it's impossible to license someone unless they took a license from the first company, we would build it into our agreements on what that will look like. So it's usually for a fixed period of time. It has to be, there's a bunch of conditions. There's about 5 conditions, but it would be rolled in if literally it can't go anywhere else. But it can't be for like 20 years. It can't be for the life of the patent. That's just, you know, you're getting free research and development work. But we've built that in now to just be a little more considerate of the fact that we know there's stuff that really can't go anywhere else. Why don't we just make it, it brings up the value of the company, gets our product maybe to market faster. Why don't we just make that simpler?
Yeah, we have the same kind of approach, but I would like to mention that there is nothing like a one-size-fits-all license. So again, it's a case-by-case basis, and because there is no one-size-fits-all, one part of the license, which is called improvements in the definition, is something that is very, very important to target in the way that we are negotiating. Are there going to be improvements? How do we reduce them to practice? How are they linked to the initial invention that is the subject of the license? And all of this is part of the negotiation. So it's a very important point. And sometimes we were talking about timing. Sometimes this takes time to achieve an agreement on this, but it's very important for the use and of course, and the value of the license and of all the IP that will be generated through.
Other question?
Yeah, I agree with both of those. We allow improvements in our licenses. Well, two ways. So downstream development. So how does that downstream development come about? And if the licensee company sponsors research back in the academic lab, certainly they get rights to the IP that comes out of research that they sponsor. If they want rights to IP that's sponsored by somebody else, that's another matter. And usually that somebody else is the federal government. So a company will license the technology and they want rights to further technology that's paid for by the U.S. government. And the U.S. government allows that, and we allow it as well, but under narrowly defined circumstances like Mark was talking about. And so narrowly defined would be for a certain period of time, usually for subordinate IP, so IP that's dominated by the licensed IP, and also where the professor agrees, because oftentimes these licenses will be for startup companies, and the faculty will be associated with the startup company, but sometimes there are fallings out. And if that happens, then the faculty wouldn't want their academic research going to a group of people that he or she no longer associates with.
Thank you for your presentation. Merci pour la présentation. I'm Jay Zakhaev. I'm a patent litigator, so I have a bit of a different perspective than you guys do on this. What I'd like to know is, what provisions do you make in your license agreements, or in your agreements rather, with the inventors that ensure preservation of invention documents that demonstrate the invention and its advantages, and preservation of access to the inventors? When we enforce, we need the invention story to defend the patent. We need the inventors to testify, if available. What steps do you take to ensure that those inventors will come back and testify and support the patent, especially if they've moved on?
You want to take that, Ken?
We don't.
Yeah.
Goodwill?
Talk to me after.
Yeah. So I can just say we have had a few cases where we've built in specific language around the license where that was maybe more likely to happen. That's, again, case by case, but we generally don't have that built in as our standard, but I can talk to you later, we have done a few cases where we do carve out what that would look like.
I was a little too flippant. All of the U.S. licenses are with institution assignment, and so we don't make guarantees for what the inventors will do. They don't own the patent anymore, but we do make guarantees about how the university will support litigation downstream.
Yeah, exactly. And we certainly try to make sure we've got all the documents around assignment to the institution, et cetera, so at least chain of title is clear, et cetera, so we do our best we can with that.
Research as well? Do you keep the research documents as well, a copy of them, or do you provide them to the licensee?
If asked, we would provide it, yeah. And we've certainly carved out, I've done licenses where I've carved out that the company has access to the prof for a reasonable amount of time, like for free, and after that it's consulting. So we've done that too, if asked. And usually that's a good thing if they really want the person to put it in writing so it doesn't become, this is a drain, they're calling me every week. I don't want to do that.
Thank you.
Thank you very much. So, thank you very much for the panelists.